Welcome back to the Constitutional Clarion. This is just a quick video to respond to some media questions that I've been getting about the consequences of the conviction of a member of the New South Wales Legislative Assembly, Gareth Ward, on charges of sexual offences. I'm not going to talk about that case as it's still subject to sentencing proceedings and of course any future appeal. This video is just about the constitutional ramifications for his seat in Parliament. The provision in the New South Wales Constitution about disqualification from Parliament upon conviction for a criminal offence is different from that at the federal level in the Commonwealth Constitution. You might remember that I did a video earlier this year about conviction and disqualification, which dealt with the application of section 44(2) of the Commonwealth Constitution to conviction. And go back and have a look at that if you're interested. The New South Wales provision, which has origins going back to 1842, originally applied to persons attainted of treason or convicted of a felony or any infamous crime. It was amended in 1999 to remove some of the archaic terminology concerning treason and felonies. It now provides in section 13, capital A1E of the New South Wales Constitution Act, that if a member of either House of Parliament is convicted of an infamous crime or an offence punishable by imprisonment for life or for a term of 5 years or more, and is the subject of the operation of subsection 2, his seat as a member of the House shall thereby become vacant. Now, I'll come back to that operation of subsection 2 shortly. However, the first thing to note is the change from the classification of felony to a classification of offences by reference to the potential maximum punishment. It refers to offences punishable by imprisonment for a term of 5 years or more, not to the actual sentence that is given in the particular case. This borrows from wording in the Commonwealth Constitution, which refers to offences punishable by imprisonment for 1 year or longer. Now, note that difference between 5 years in New South Wales and 1 year at the Commonwealth level. It means that the Commonwealth disqualification applies to a far wider range of offences than the New South Wales provision does. A New South Wales Parliamentary Committee argued in 1998 that the provision should be amended so that it applied to the actual sentence imposed by a court, because this more accurately reflects the severity of the crime. It also thought that it should be set at sentences of 1 year or more, but no such change was made. Even though the disqualification provision is included in the New South Wales Constitution, it does not require a referendum for its amendment as long as any change applies in the same way to members of each House. Hence, change is possible if you've got a majority in each House to support the reform. But in addition to conviction for offences punishable by 5 years or more, the New South Wales provision also disqualifies members who are convicted of an infamous crime, regardless of the potential maximum sentence. It therefore picks up crimes with much lower maximum sentences. But what is an infamous crime? You'd think that by being called infamous, it would be pretty obvious what it was, but in fact, it's not quite so clear. It seems to be derived from the types of offences which in times gone by disqualified a person from giving evidence before a court or for being a juror in a criminal trial. These offences involve some kind of deliberate deceit so that the person could not be trusted even if they gave evidence under oath. Infamous crimes therefore include offences like fraud, forgery, perjury, bribery and perverting the course of justice, rather than other types of criminal offences like those involving violence. It was held in Troutwine's case that the offence of making false statements to a Commonwealth officer about the execution of a document was akin to forgery and therefore an infamous crime. But when another MP was convicted of taxation offences, there were competing legal opinions about whether this amounted to an infamous crime. He resigned, so the issue was never resolved. Another interesting difference is that the Commonwealth provision applies to any person who has been convicted and is under sentence or subject to be sentenced for the offence. It applies to prevent the person from being validly nominated, elected, or sitting as a Member of Parliament while serving that sentence, or indeed awaiting sentence. The New South Wales provision only applies if a person who is already a Member of Parliament is convicted. Theoretically, a person currently serving a sentence could stand for Parliament and be elected as long as the person had not lost their right to vote, which would happen if they were serving a sentence of imprisonment of 12 months or more. The biggest problem with timing, however, arises in relation to appeals. What if a person has been convicted, but then had their conviction quashed on appeal or had their conviction annulled? If there was never a valid conviction, how does that affect the consequences of disqualification? For example, outside the parliamentary sphere, there used to be a New South Wales law which said that if a railways officer was convicted of a felony, he shall be deemed to have vacated his office. When a railway employee's conviction was later set aside on appeal, the High Court, in the case of Commissioner for Railways New South Wales and Kavanagh in 1935, held that the employee was entitled to recover unpaid salary. This was because his conviction had been quashed and he therefore could not be considered to have been convicted or be deemed to have vacated his office. But what happens when that office is filled by a person who has been elected to it in the meantime? That democratic mandate would seem to override any claim to reinstatement. In the United Kingdom, for example, it was held in the case of Attorney General Jones in 1999 that if the MP whose seat was vacated by conviction has the conviction overturned, he or she may simply resume the seat as long as it has not been filled in the meantime by a new MP. If a by-election has been held and the seat has been filled, then the overturning of the conviction of the previous MP cannot affect the outcome, as there's no longer a vacant seat to be resumed. In Australia, this issue was raised in part at the federal level in the case of Ree Cullerton, No. 2, in 2017. Rodney Cullerton had been convicted by a local court of larceny prior to his nomination for Parliament, but had not yet been sentenced. After his nomination and his election to the Senate, his conviction was annulled. The High Court, operating as the Court of Disputed Returns, held that the annulment only operated with prospective effect, so that Cullerton was still the subject of a conviction at the time that he was chosen as a senator and therefore disqualified. The court did not have to determine, however, whether a successful appeal, which quashed a conviction, would be treated differently. In New South Wales, the problem was addressed by constitutional amendments that were made in the year 2000. Subsections 13 A, 2 to 5 were inserted to clarify what happens if a conviction is appealed. Instead of disqualification happening automatically upon conviction, it instead occurs if the member has not lodged an appeal against the conviction within the prescribed period, the conviction has not been quashed on the determination of an appeal or appeals lodged within the prescribed period, or such an appeal has been lodged within the prescribed period but has been withdrawn or has lapsed without being determined and no other appeal lodged within the prescribed period is pending. Now, that's the rather technical description from the Constitution, but the TLDR is that conviction happens once you have reached the end of the appeals process, if you choose to appeal, and not had the conviction overturned. References to the prescribed period exclude any extension of that period which a court may grant, and that's to achieve some kind of clarity in relation to timing. There's one other important thing to note. Subsection 13 capital A3 says that nothing in this section affects any power that a House has to expel a member of the House. The Minister, in making the second reading speech for that amendment, explained why, saying, "In some cases, the behaviour of the member may be such that it is unacceptable that the member continues to sit as a member while the appeal process is underway. In such cases, the House will retain its discretion to expel a member for unworthy conduct by way of a vote of the House. Other options may include suspension of the member or the granting of leave to the member so that he or she does not sit during the appeal process. This ensures that the House retains the flexibility to deal with members in a way that is necessary to preserve public confidence in the integrity of Parliament." End of quote. Unlike disqualification, which occurs automatically at the point when the constitutional requirements are met, expulsion or suspension require a vote of the relevant House. As explained in previous videos, neither expulsion nor suspension can be used in New South Wales for the purpose of punishment. They can only be used for the protection of the House and its ability to function. Finally, has anyone been disqualified on the grounds of conviction in New South Wales before? Yes, but it is rare because members charged with offences ordinarily resign first. There are a few examples. For example, in 1905, Thomas Slattery's seat in the Legislative Council was vacated after he was convicted of a felony of stealing money. Alan Millard's seat in the Legislative Assembly was vacated in 1906 after a conviction for misappropriating funds from a client. And of course, Theodore Troutwine's seat was vacated in 1940 after he was convicted of the infamous crime mentioned earlier, which involved making untrue representations about documents in order to avoid bankruptcy proceedings. While other MPs in New South Wales have eventually been convicted of offences ranging all the way from murder through to misconduct in public office, this has occurred after they've left office. With regard to Mr. Ward, what happens now? He could decide to resign his seat in Parliament. He could decide to appeal his conviction, or he could do nothing at all and become disqualified. If he appeals, and this might take quite a long time to resolve, the House retains the option of suspending him or expelling him. But again, this must not be done for punitive reasons. Thank you very much for watching the Constitutional Clarion. I hope this clarifies matters for you. And as always, I look forward to seeing you again next time. Goodbye.